to make sure that we have clean water and environmental protection. A show of hands. How many think that that's, oh, okay, good for you. I thought most of you would believe that. How many of you think that in the event of a violation of the Clean Water Act or other environmental regulations, that those penalties should be fair and balanced regardless and without favor or prejudice against or for the violator? Should it not be a fair and balanced process? Everybody agrees with that. Well, I'm going to upset you. I'm going to give you a disclaimer that you're going to be irritated by the time I'm done. So, it says Forrest, Sprague, consultant. Now, a lot of people take issue with that term consultant, and I understand. But I have to tell you that there's some history that brought me into this activity that I pursue currently. Back in the 1990s, I was chief of staff for Senator Maurice Johannesson, who represented our district in the north. In fact, I'd like to chat a little bit further with the lady from Siskiyou and ask her or answer the questions she had about the water-related issues here in California. But at any rate, during that time, I crafted a lot of legislation. I was the principal consultant to the senator, crafted some legislation that dealt with agricultural interests and in favor of agricultural interests. One particular, I won't get into the details, but it really trimmed some of the strength and overreach that California Department of Fish and Game, then Fish and Wildlife now, had, and it really put the farmers and the property owners back into the driver's seat in dealing with fish and game. Now, that bill was supported by all of the farm bureaus within California, cattlemen's associations, Western growers associations, all agricultural interests up and down the state. In addition, flood control districts, public works departments, reclamation districts, and so on. It was opposed by the Sierra Club and several other of those environmental related organizations. So you can tell that it was, in fact, a favorable bill to agriculture. We went through the process. Upon signing the bill, the governor, Pete Wilson at that time, his chief of staff told me that the governor does not like signing this piece of legislation. But Forrest, you brought the issue to such a height of public awareness, he's got no choice. And I'd say that not to bring attention to myself or to suggest to you that I'm somehow important. What I want to do is emphasize how important what you are doing. You are bringing these issues to a height of public awareness, and that's when things will change. So I can encourage you to continue doing what you're doing. So having said that, which button do I push? I'm sorry.
One on the right.
One on the right. The Army Corps of Engineers versus John Duarte. You've heard a little bit about it. You know the history on it. I'm not going to read through this. I only hold it up for show and tell purposes. This is the book that the court literally threw at John Duarte. I've perused it. It's authored by several quote-unquote experts. They've given their opinion of that particular project in here, and opinions like noses smell. It's not based on facts. It's based on speculation. It's based on just a whole bunch of stuff. Having been a facilitator for such reports, I'm going to suggest to you that our tax dollars were probably somewhere in excess of what, 100,000, 150,000? You have any idea? I can speculate that that's how much. The point is, I'm going to go over, just highlight a couple of the key issues in regard to that court decision. One was John had to agree to a civil penalty of $330,000 paid to the United States. Number two, he spent or had to pay or has paid $770,000 to purchase vernal pool credits from National Fish and Wildlife. And he's had to forfeit the use of my calculations in reading it, he may be different, about 50 acres of his land for at least 10 years that he can't use. Now, here are some of the key figures in that particular court case. I draw your attention first to Kimberly Mueller at the bottom. She was the judge, as John pointed out earlier. She was appointed by Barack Obama. And then Jeffrey Wood and Andrew Doyle, key figures in the prosecution, working for the United States. But let's first take a look at Kimberly. Now, I'm going to point out here that she was an appointment by Barack Obama. But I want to ensure that you good folks understand that this is a nonpartisan problem, in my view. I don't care if you're a Republican, Democrat, Libertarian, or even a vegetarian. The issue is the same. It's a cultural issue. It's a government culture issue. It's government culture combined with elite environmental culture and combined then with urban culture, all attacking agriculture. That's what it is. That's the problem that you're up against. It's nonpartisan. It's our government officials and the environmental elite that is the problem. And I can say that with confidence. Point to you, Jeffrey Wood. You'll remember the name, excuse me, on the court decision. Who is Jeffrey Wood? He is the acting Attorney General for the Environmental and Natural Resource Division of the Department of Justice. He has past served as environmental counsel for U.S. Senator Jeff Sessions. Where's Jeff Sessions now? Our U.S. Attorney General. He is also past Republican staff director for the U.S. subcommittees, Senate subcommittees on clean air and water. That's his history. Now, this is from his written testimony given to an oversight committee back in June of 2017. Now, in his position, wouldn't you like to think that he would, in an environmental capacity that he has in talking to a regulatory committee, that he might lift up and saying, since our activity in the last 20 years, we've cleaned up the water in 20 lakes, or 100 lakes, or 50 lakes, whatever. Or we have taken off X number of species off the endangered species list. Or we have done this, or we've done that. Wouldn't you like to think that that would be something that he would hold up as a crowning achievement for his division? But look at what he holds up. Environmental and Natural Resources Division has successfully litigated 800 cases in fiscal year 2016. Second, he holds up that we have obtained over $3 billion worth of corrective measures through court orders and settlements. Fiscal year 2016, we secured $14 billion in civil penalties, natural resource damages, and other civic monetary relief. Those are the crowning achievements. He's a Republican, but he's a bureaucrat, and therein lies the problem, folks. Andrew Doyle, his second in command. Also, again, working for the Department of Justice. He's a volunteer for the bar pro bono program. And the articles that I've read about him, he focuses mainly on environmental justice law. Now, here's an interesting letter, and I've got to put out the caveat that this is merely speculation on my part. I have experience in the legislative process, and what had happened after John's court decree, well, it was a public comment period, 30 days, 45 days, 30 days? 30 days, which allows then for any concerned parties or interests to comment on the court decree. Now, what normal procedure is that if I or you or some other organization has a concern about the decision that came out of the courts, you would send that complaint or that observation of yours to either the court or to the U.S. Department of Justice. But since this organization, Clean Water Action, they call themselves, complaining about the consent decree, saying that the goal falls well short of the remedy for such a case, since they sent it directly to Mr. Doyle, I have to ask what kind of a relationship that they might have, because that is totally against all normal protocol. But merely speculation, I'll let you conclude what kind of arrangements that they may have had. Now, this is John Doherty's property. I'm going to ask as we go through these slides and the rest of the slides that you keep in your mind Mr. Doherty's property, because it's very, very telling and very interesting. This is on the north side piece of his property. It's called Coyote Creek. It's what he's accused of damaging and polluting. And as you can see, it's nothing but a dry riverbed, not even a riverbed, but a creek bed that has water in it only when it's severely raining. This is another piece, or another picture looking east towards the Sierras. This, John showed you earlier some slides, this is the type of thing, and even smaller ones, that the Army Corps of Engineers calls streams. And this is nothing but a rock bed, as you can tell. And this is some of the wheat. I think I took these last summer, probably about June or July of last summer. And of course, this is another one that they call a stream or a wetland. And you can see that it's nothing but arid and dry land. Now, I want to compare this, or I want you to look at some of these statements without getting into too much detail. Some of the court settlement or statements against Mr. Doherty, what they accused him of. They didn't prove that he did it, they just charged him with it. First, they identified here under the Clean Water Act, a pollutant includes dredged soil, biological materials, rock, sand, and soil. Now, this ought to alarm every one of you farmers. If you were to convert maybe your pasture land to trees or vines, or if you change the crop from maybe corn one year to something else next year, if you do any activity, they can claim you've polluted the water. Discharge of dredged materials includes material incidental to any activity, including mechanized land clearing. Any activity, including mechanized land clearing. The courts have found bulldozers to be point sources of pollution under the Clean Water Act. Now, one of the things that makes me successful in what I do as a consultant is I'm bilingual. That means I speak regular English just like you good folks, but I speak bureaucrat. This, let me translate this for you. This says, no matter what you do on your property, I, as the federal government, can determine it's illegal. No matter what you do. Any activity, including any one of those, that's the way the court decisions came down. Notable quote, John talked about this earlier, he asked for, which is perfectly legal within the Clean Water Act, for an agricultural exemption. The court said they're not persuaded that after nearly 24 years of no activity that meets the applicable definition of farming. About 20 some odd years ago, Mr. Doherty's property was in wheat. Wheat prices went down, things changed, they turned it into grazing. John bought the property, tried to turn it back into wheat, got shut down. And the reason is he could not claim an agricultural exemption because the court said it was for 24 years since it had been in wheat. Therefore, he was denied an agricultural exemption. Now, I want you to compare this to a county, or a lake, a stream, about 2 miles south of my property in Glenn County, about 40 miles south of Mr. DeWardy's property. This is Walker Creek. It flows eventually into the Sacramento River. Now, keep in mind what John's property looked like. This has riparian habitat, a lot of water in it. I took this a couple of weeks ago. It's a little high now, or then, because of the recent rains and so on. But it is usually a year-round creek under normal conditions. It's the home of beavers, garter snake habitat. It had, or used to have, until you see these pictures in the future, a couple of trees that did have Swanson hawks, which are on the Endangered Species Act. It's not uncommon to see grandpas like me take their grandsons out and go fish here. We get bluegill and some crappie and sometimes a carp or two, but nevertheless, it's a fun spot to go. But it is truly riparian habitat, and it does flow into the Sacramento River. This is what it looked like in the summer of 2014 because of the sustained drought. But nevertheless, you can still see that it is in fact a creek bed full of vegetation, without doubt, lots of critters and bugs and all sorts of things in it. This is again what it looked like in the fall, but here's what it looked like after Glenn County Public Works got done. They gutted that entire creek wide enough, long enough, and flat enough to land a small airplane. Now, I brought this to the attention of the Glenn County Board of Supervisors, the chairman at the time, showing my concern over this, because right down here, you can see it turns off to my right. It does a 45-degree bend as a train trestle. And I know by experience that when the water were to hit, if we had an exceptional rain year, water would hit that, catch the velocity, the debris would go up against the train trestle, and it would flood willows to the south. Now, I presented that to the Board of Supervisors, or one of the board members, and I was told that if I just keep my mouth shut, nobody would know. Nobody took any action whatsoever. My concern was not to go after the county for what they did. My concern was for the potential flooding that was going to happen. December 2014, we had a deluge, and it flooded exactly where I said it was going to do, and where it was going to flow, and how it did it. So, but ahead of time of that, because I was getting nothing from the county, I contacted Regional Water Quality Control Board. But first, let's take a look at what the court told Mr. DeWardy on his property. The court told Mr. DeWardy the Clean Water Act defines material to mean changing the bottom of elevation of any portion of the water of the United States. They parked equipment, sometimes a week, week and a half at a time. No drip pans underneath it. Just stay there. And the Clean Water Act, of course, requires that you do not leave for a period of time equipment in a creek bed. Nevertheless, they did it. What the court told Mr. DeWardy, the courts have found bulldozers to be point sources of pollution. Glenn County piled material on both sides of the creek. But remember what they told Mr. DeWardy? We have found bulldozers to be point sources under the Clean Water Act, whereby excavated dirt is piled on either side of the ditch. As you can see, some of that material is piled. If you look closely, you'll see a lot of biological material. We call that wood, okay? But you can see it there. What did they tell Mr. DeWardy? Pollutants include dredged soil, biological material, rock, and sand. So as I said, I called the Regional Water Quality Control Board, again, not to try to get them in trouble. I wanted the problem fixed so that when the rains came, we wouldn't have a problem. So they did. They came out and looked. On December of 2014, just a few days, about a week before the big storm that we had, came out and identified, as you can see at the bottom, non-compliance with the Clean Water Act. Now, about a month and a half after that, the Regional Water Quality Control Board also fined Glenn County for at least $61,000. And they calculated that by the amount of material that they actually excavated out of the creek. When I asked the Regional Water Quality Control Board why they did not go through with collecting on that fine, the answer I got was, we just don't like to go after small counties. We know their budgets can't absorb the penalties. I also contacted California Department of Fish and Game. They came out, did their own notice of violation. They revoked the streambed alteration agreement that the county had at that time. They also, their own report here, and I'm sorry this is kind of a bad cut and paste on my part, but you'll notice that they do say, notice significant width of the creek bed due to the removal of all vegetation. Also, another picture here, but they also talk about the sand and gravel piled, pushed along the trees and the other banks. Of course, again, those were some of the violations that they used against Mr. Dougherty. Now, with respect to California Department of Fish and Game, what they required the county to do was to go in and do a retroactive or after the fact permit where they had to spend. They spent about $60,000 or $70,000 on doing hydraulic studies and so on to justify what they did. But again, when I asked them, what about the penalties that my clients and any private landowner would have to go through? And they said, Forrest, we think the cost of the reports was adequate. So they passed it off altogether. But here was the clincher. Army Corps of Engineers was notified, not by me, but it was part of the process, especially with the Regional Water Quality Control Board. But here's what they said in November of 2016. Upon our investigation, we have determined that the maintenance activities performed within Walker Creek during October of 2014 qualify for a maintenance exemption under the Clean Water Act. Now, here was the reason. One of the reports that was provided stated specifically this portion of Walker Creek is a channel constructed during the realignment of Highway 99, built in 1936 and realigned in 1951. 67 years ago, okay, they get an exemption for maintenance. Mr. Dougherty asks for an exemption for agricultural activity, and he's denied because he hasn't done the farming for 24 years. But 67 years they go back to and give an exemption. The problem here is the Army Corps of Engineers nullified any further investigation or penalties from the two state agencies involved. And that's, yeah, this is again what they told Mr. Dougherty, that nearly 24 years of no activity is not the definition of farming. More claims against Mr. Dougherty. The term person, that, I have to be honest, some of these citations, in my view, did not apply to a private individual such as Mr. Dougherty. Nevertheless, I'm going to cite them because they were, in fact, in the court case. Term person is defined to mean a political subdivision of the state. Now, a county is a political subdivision of a state. Individuals whose acts have led to such pollution et cetera, for working in the capacity of an employee or officer of the entity that owns the property in question. Now, what I just showed you was a county-owned piece of property. I'm about to show you another county-owned piece of property. And under the Clean Water Act, penalties may be imposed against individuals who are in positions of authority. And again, I don't know why they cited these particularly for Mr. Doherty's case, but nevertheless, it's part of the court record against Mr. Doherty. So when I glean this information and then compare it to a County Road 44 project, I have to scratch my head and wonder if they're going to apply these laws to Mr. Doherty. Why aren't they doing it to the county? This is County Road 44 project. By way of history, this is on a county road. Sorry, a little thirsty. On a county road that's considered to be a farm to market road. And as a result of that, several years ago, one of the bridges going over Colusa Basin drain became corroded and was necessary to replace it. So the county went after a federal grant and got the money for it. But because of its location, it's about a mile off of the Sacramento River, it takes the water from the Sacramento River, and as Angus pointed out earlier, Sacramento River is one of those rivers considered to be navigable water. So this water, since it originated from the Sacramento River, and the tailings after it irrigates the farm fields close by go back into the Sacramento River, this project became very scrutinized. They had to do an EIR, a biological opinion, and so on. And one of the things that they had in it, or several of the things, was the erosion control and the necessity to protect the water from any source of pollution. But in 2014, they ignored all the rules, and Regional Water Quality Control Board came in and shut them down for non-compliance with the Clean Water Act. So what the county had to do, they had to go in and put in straw netting and other erosion control devices around the project to keep the soil being a pollutant, from entering into waters of the United States. So they went through a pretty extensive effort. As you can tell, I didn't take all the pictures that were available for what they have done, but they did a proper job in December of 2014 to protect the water of the U.S. But by the time 2015 came around, this material in here, these straw wattles that you'll see down here, by design are not to be there for very long. They're only to have a life of about maybe 6 months or so while the project is going on. But the county abandoned the project and allowed the site to become completely deteriorated and non-functional as far as erosion control. Sediment was allowed, erosion was allowed, sediment was allowed, construction material started flowing into the water of the United States, more erosion control, so on. So this went on, and the problem here is that this was along the Sacramento River. There's a few hundred farmers in this particular area that the Department of Fish and Game, U.S. Fish and Wildlife, are constantly patrolling and constantly making these farmers in that area walk on eggshells. They dare not spill a half a gallon of diesel fuel. They'll be put in jail. But all those same farmers know that this project existed. So I was contacted by them. Names will remain anonymous, obviously. And what could I do? They wanted this road fixed. They wanted to finish it up. But at the same time, they know the scrutiny that they're under from these regulatory agencies, and they can see this pollution going on all the time. So I contacted Regional Water Quality Control Board, Department of Fish and Game, U.S. Fish and Wildlife, Caltrans, California EPA, U.S. EPA, and gave them all a 17-page full-blown report pictures and narrative and all, a very condensed version of what they used against Mr. Doherty. Nobody answered. Nothing. Finally, I continued to push and push and push, and finally, in the end of September 2017, last year, Regional Water Quality Control Board finally came out. Here's what they found. Now, these are their own pictures. These are not mine, these are their own. Notice they say no erosion control, PBM, that's an acronym for best management practices, in violation of the Clean Water Act and environmental acts. They also indicated here no erosion control, but notice down here on the bottom, these are the same violations that they found in 2014. So this project sat there for 3 years with all the government agencies that went after Mr. Doherty, full knowledge that this was going on. They identified construction material that had been there since 2014, chemical stuff that was stored there, again, you'll see, left since 2014. Whoop, I'm not getting. But here's the clincher. Here is really the clincher. They had to, by law, well, I'm sorry, here's some oil left there. Again, this is near the waterway. But here's the clincher. By law, they have to put what's referred to as a turbidity curtain over the water so that any sediment and so on, they trap it and keep it. But look what they've done. They've actually secured one end of that turbidity curtain with chemical containers, quote unquote. Now this is Regional Water Quality Control Board. This is not me. This is not, I didn't create this stuff. This is Regional Water Quality Control Board. All of this stuff in 100% violation of the Clean Water Act, Environmental Protection Acts, Army Corps requirements, anybody and everybody that you think of, any agency, all of this stuff is in direct violation of their requirements. This is from the streambed alteration agreement that the Department of Fish and Game did with Glenn County. This is interesting that this agreement was actually written and signed in 2016, June of 2016, a full year ahead of the pictures that I just showed you. I've got emails from the consultants and county staff showing that they knew that this pollution existed when they entered into that agreement with California Department of Fish and Game. And you can see specifically they've got sediment control requirements and so on. The next page, they've got pollution control requirements. But those projects were in complete violation of California's Fish and Game streambed agreement. And then after now a couple of years, finally I get a response from Fish and Game telling me that they've investigated it and that the project is in compliance. But here's where it gets really interesting. This is a letter signed by the biologists for the project. These two ladies are approved, quote unquote, approved biologists by the California Department of Fish and Game to oversee the project. Now let me give you some translation here on their concern. Whoop. Here's what she says. I had the discussion about a week in advance of this receiving this letter. And this was Carol Wallen that called me. And she told me, she said, if I continue to go out onto that project, now realize this is a public works project on public property, asphalt roads that I'm standing on and taking pictures. If I continue to go out there, they will report me to the California Department of Fish and Game and to what's referred to as CalTIP. CalTIP is an acronym for Fish and Game, California's Turn-In Polluters. And it's very specific on their website why it exists. CalTIP was introduced to give Californians, of which I am one, an opportunity to help protect the state's resources. It also says the program encourages public to provide CDF with information leading to the arrest of polluters. And it also says, be prepared to give the fullest account of the incident, including the type of violation and so on. When I first brought this to the senior biologist of the Fish and Game people in Sacramento, they told me to call CalTIP. Call CalTIP. So I did. I made 3 reports before anybody responded. Now, but she threatened me that she was going to have me arrested. Here's the English translation. Oops, Forrest caught us. Oops, Forrest has got enough guts to tell the public. Oops, Forrest is right. Oops, we have no defense. The best defense is a good offense. And that's what they came after me for. Now, real quick, this is the last one for me. This is what's going to make you mad. Notice this says state water quality enforcement policy. And this is the penalty calculations. Now this is a policy, not a law. This is their policy. It says civil penalties do not depend upon proof of actual damages to the environment. The courts have held the plaintiff need not prove loss before recovering a penalty. Instead, the defendant, Mr. Doherty and others, must demonstrate the penalty should be less than the statutory maximum. Civil liabilities be set at a level that accounts for any economic benefit or savings the violators gained. That's what it says in bureaucrat. Here's what it says in English. I don't have to prove that you harmed anything. All I have to do is prove that you did an activity. I don't have to prove you damaged anything. I just have to prove that you have the ability to pay for the penalty. That's what that says. That's what that says. Okay? No proof. In fact, the reason that they don't want to charge and identify that you had or did not do any damage is because then you have a defense. If they would have charged Mr. Doherty and said you killed 10 salamanders, he now has a defense and says, no, only killed 8. But they don't want him to be able to defend himself. So they take any harm out of the equation for attacking him. If they had identified you damaged 10 salamanders, they would have to identify a cap on how much each one of those salamanders are worth. And thereby, if they were worth $1,000 a piece, you killed 10, you owe us $10,000. But that puts a cap on the violations. The only defense by this policy that a violator has is, I can't afford to pay the bill. That's the only defense. Worse than that, we just settled a case that unfortunately I got involved into it too late. But the violator, after 17 years, agreed to pay $25,000 a year for the next 10 years to the Regional Water Quality Control Board or to the state. And it specifically said in the testimony when the attorney for the violator asked the Department of Fish and Game, what harm did he actually cause? And the answer was, from the California State Attorney General's office, we do not have to prove that he did any harm at all. All we have to prove is he can afford to pay the bill. They did an audit on his business and his property, his equipment, and then calculated the bill. Not based on any harm that he did, but just strictly his ability to pay. That's what you're up against, folks. That's what we're dealing with. Thank you. Questions?
I have the first question, I don't know, Forrest, if you want to answer it or John, but if that land, we're talking about your farm, was in wheat 24 years ago, it was grazing cattle for 24 years, and then you plant wheat, why is that grazing cattle not considered an agricultural exemption or agricultural use?
You're speaking English. You're speaking English, Trent.
I don't know bureaucracy.
Well, like I said, the language is written, and what they do is regardless of your activity, regardless if they identify soil, they've identified soil as a pollutant. Come on. Okay, so all it is, it's just written to, if we want to charge you with a violation for any activity that you had, we have the authority to charge you for that. That's all it is. So you're trying to think logically, you're trying to think like the rest of these people using English language for what we understand English language to mean, and it doesn't mean the same thing when you're talking bureaucrat.
I thought we chased out the phone and called him a racketeer and then for doing this. Other questions? You are now in the lead of Reed Smith. You better step up his game.
It's what you were describing at the very end.
Yes.
It sounds to me like the precautionary principle, that if you could do harm, then they can go after you. It's not that you did do harm.
You got it. And what you're describing is what I do. Okay, what you're asking about is what I do. When a potential violator either preemptively trying to avoid getting into trouble or finds himself in trouble, as opposed to litigating, I try and mitigate. And because I speak both languages, I can usually try and meet the objectives of both parties and come together and not mitigate, but solve the problem. Because I know if they litigate, they can't win. I at least have a chance, like Angus was pointing out, if we know what the laws are and what the requirements are and hold them to the law, not to the policy, but hold them to the law, we usually can win. Not going to court, but by mitigating.
So this is why teenagers drink beer. Peer pressure works.
Forrest, are we not in a position to use the insider-friendly lawsuit process where Friends of the Earth, Environmental Justice, or Environmental Defense Fund, name your eco-racketeer? Are we not in the same position to use those same processes against these agencies?
We actually are, to be honest with you. The Federal Clean Water Act has an ability through bringing about a civil suit against those violations. If the state agencies and federal agencies did not do anything, you and I are a group, we could call ourselves Clean Water, whatever, or environmental groups or whatever, can sue. What you have to do is you have to give them 60-day notice, those agencies in the county, and saying, here's what we're about to do if you don't do. Now, what happens with that, sometimes then the state or federal agencies that were in charge of that, oops, the gig is up, we got caught. They'll go in and then put penalties on them with the idea that they've preempted the suit in there. So you can do that. In my personal case, is I've got copies of the emails from the Department of Fish and Game, or excuse me, from the consultants that I pointed out there, that had phone conversations with Fish and Game people. And they alluded to it in their emails to other county employees. Can we get the sheriff after Mr. Sprague? Now here's what's interesting, and here's where I'm headed with this. By ethics, because of my background in working for the state legislature on not only as an ag and water, but Cal Fed and the Bay Delta stuff and so on. By ethics, if I see something, I have to say something. The Whistleblower Act protects me from persecution or prosecution by them. That act actually goes one step further. If I was in violation of a code or not, if I was found in it, I am still protected because what I brought to the attention was far more violation than what I did to bring it to their attention. So I'm protected. And I'll be meeting with my attorney in a couple of weeks to continue with that particular process. Yes.
You have a question? Somebody has a question? Oh, you want to what?
Forrest, I just want to thank you for all this work. You've been Forrest has not only been a champion of rights for all of us and equality. I want to start the Center for Rural Equity, or Regulatory Equity, and have Forrest run it so we can bring the pressures that these agencies put upon private landowners to the public landowners. And Forrest has been a great friend and a great encourager through many difficult times. So thank you, Forrest, for what you do. I hope we all can appreciate you for taking this on yourself.
Yeah, you bet. Please do. Thank you. I got one. This young lady wasn't here when I first started speaking, but she asked a question that I'd like to finish up answering for you. You asked it earlier of Mr. DeWarty on what are we doing for the Water Act. Now, I didn't realize when you asked that question, you're from Siskiyou County, you'll recognize the name Senator Maurice Johannesson. I was his chief of staff when he was the senator. In addition to being an Ag and Water and Natural Resources consultant to the senator and to the state senate, when the Cal-Fed Bay Delta program came down in the 1990s, and for those of you who don't know, it was a big federal state agency objective to clean up the problem with the San Francisco Bay and the Bay Delta and all the rivers and so on. It was so monumental in size and in scope, the state senate chose to make a select committee to oversee that particular process. I'm pleased to say, whether I was pleased or not to do it, I was pleased to say that I was appointed to oversee, I was the chief consultant of several consultants to oversee that Cal-Fed Bay Delta program. To answer your question about the water problem was identified by me and my team in looking at that Cal-Fed Bay Delta program. They had 10 primary objectives in that program: levee restoration, ecosystem restoration, save the fish, flood control, water reliability for agriculture, water quality, water reliability for urban, and so on. We went through their stack of studies that measured 53 inches tall. I condensed it down to something no more than an inch. Every one of those objectives gets met with more storage. Every one of them gets met with more storage. That's politically incorrect. The answer to your question, the answer is there. The state legislature has known it for years and years. It's just not politically correct. I am pleased to say, just 2 seconds more, pleased to say that my senator, Jim Nielsen, and my assemblyman, James Gallagher, introduced a couple of years ago, albeit contrary to what they normally believe, they introduced a bond. It was Proposition A1, if I believe, that set aside money for brick and mortar for more storage in California. But that's still been opposed. Even though the money is there, it's still being opposed by the environmental groups, hence the legislature's not going to do anything toward it.
And their goal is to destroy, start with the 4 dams on the Klamath, and then they'll do full basin management by the year 2021 to get that project started.
Right. Well, to get the Cal-Fed Bay Delta project started? Or?
Destroy the Northern California, Siskiyou County dams.
Oh, yeah.
They are going full forward, and these are clean, green, renewable, almost in perfect condition dams. Most people don't know about it because there's so much swag, like I call swag, scientific wild ass guesses going on
Right.
in their EIRs and EIS, is that anybody with common sense would say, why are you going to destroy largest dam destruction project in worldwide history? Sorry, Trent.
Yeah.
But if everybody knew about it, I would hope that people would be standing on those dams and saying, over my dead body, are you
Yeah.
going to destroy California's water infrastructure? Any
Don't
further-
answer.
And
We have an hour open discussion this afternoon. All of these things
We'll
will
do that.
continue.
You bet.
We're going to eat right now. Forrest, Sprague, thank you so much. You're at risk of being called Angus McIntyre.
thank you for your attention. I appreciate it.